Hello, my name is Tony Tyre, and I'm sitting here with Espie, and today we're going to be answering some questions about estate planning.
Tony, what does an estate plan mean?
That's a really good question, Espie. The most important estate planning document is typically considered a revocable living trust. The benefit of having a trust is to avoid probate court, and the reason why we want to avoid probate court is number one, because it's very expensive, and number two, because it's very time-consuming. Secondly, we typically draft a pour-over will. The benefit of having a will is that it's a way that we can make sure that the terms of your trust are properly followed. Third, we typically draft a power of attorney. A power of attorney is a document for incapacity and specifies who would be making financial decisions for you if you're unable to make them for yourself. And then last, we would typically draft a healthcare directive, which does a very similar thing, but that specifies who would be making medical and healthcare decisions for you if you couldn't make them for yourself.
Tony, what's the difference between a will and a trust?
Good question. A trust is a document that really allows us to avoid probate court. And another benefit of having a trust is, especially if you have minor children, we could specify rules that would help care for your children if you're no longer here. So for example, a lot of our clients will draft a trust that has educational provisions. So if you were no longer here to make decisions for your client or for your child, we could set up certain rules to ensure that that child is cared for in the customary way that you would want them to be cared for. A will is a much more simple document. A will is perfect for somebody who potentially doesn't have minor children or has more limited assets. Now, the benefit of having a will is that it's a much easier document to draft, but the negative thing about having a will is that no matter who drafts the document, you always have to go through probate court. And again, probate court is very expensive and time-consuming, so we always try to avoid court if at all possible.
Tony, what is the difference between a durable power of attorney and a medical health directive?
They're very similar documents. Both documents are documents of incapacity. So what that means is that they only take effect typically if you are declared to be incapacitated. A durable power of attorney takes care of financial matters. So for instance, bank accounts or retirement accounts. If you're incapacitated, we can specify who your attorney in fact would be or your agent to help make decisions for you regarding finances. A healthcare directive is also an incapacity document, but this comes into play for medical decisions. So if you're unable to make your own healthcare or medical decisions, we could specify who that person would be, and then we can also specify what rules would you want this person to follow. So two things we commonly talk about would be number one, would you want to donate your organs? And number two, would you want to remain on life support?
Tony, what is a special needs trust?
A special needs trust is a specific type of trust for a person who receives government benefits, such as Medi-Cal or SSI. Now, the main benefit of having a special needs trust is we can allow that beneficiary to continue to receive the government benefits, which oftentimes are really needed, yet we can keep this money aside to supplement that person's needs.
Thank you for that. That's very interesting. Are there different kinds of special needs trusts?
There are. The two most common special needs trusts that we talk about would be, first of all, something called a first-party special needs trust. And what that means is that the person who is the beneficiary of the trust is actually drafting the trust. The nice thing about a first-party special needs trust is the person actually gets to make all of his or her own decisions, but the negative thing is that when the person eventually passes on, or when the trust eventually ends, there are government payback provisions. Now, in contrast, a third-party special needs trust is drafted by somebody else. Typically, this would be a parent or a grandparent for the benefit of a third person. The best thing about this sort of trust is that there is no government payback provision. So the great thing is we can have the beneficiary keep their benefit. We can also have money in the trust to help supplement that beneficiary's needs. And then when the trust ends, the government does not receive any sort of payback.
Thank you for the clarification.
You're welcome.
Tony, what information do I need to draft an estate plan?
Good question, Espie. Most people are surprised to hear there's really not that much information. What we always like to say is there's two components, people and then things. By people, we just mean your information, your children's information, your beneficiary information, and who you want to be in charge. And by things, we just mean a list of your assets. So real property, bank accounts, retirement accounts, timeshares, anything like that. We want to know what you have because depending on your beneficiaries and depending on your assets, we'll give you specific advice for how the assets should be held and why.
You mentioned the term beneficiaries. What does that mean?
That's another really good question. So a beneficiary would be the person that the trust would ultimately benefit. So for example, for most of our clients, the person who creates the trust is actually the initial trustee, meaning the person in charge, but also the initial beneficiary. Now, typically, the person who creates the trust will name a secondary beneficiary, and that person would be the beneficiary typically when that person passes away. So a great example would be parents. They may draft a trust and move their house into the trust, and for the initial term, the house would be for the parents' benefit, but then ultimately, once the parent eventually passes on, at that point, that's when the children would become the beneficiaries of the trust.
Thank you so much. That really does help.
Oh, you're welcome, Espie. And if you have any other questions, you can always feel free to contact our office, either by telephone at 626-858-9378 or through our website, which is tyrelawgroup.com. That's Tyre lawgroup.com.